Use Week. As a reminder, today's webcast will be recorded, and we'll email out the link to the recording in the next few days. Sorry, I have a cold, so apologies. I see some folks are having some issues with audio. We will try to address those shortly. And as I mentioned, this session is being recorded, so if people have trouble, we'll be able to provide the full archive shortly. Our presenter today is Anna Enriquez. Anna is a copyright lawyer who focuses on the issues facing libraries, universities, and other cultural institutions. She has taught copyright and internet law and is a member of the Illinois and Massachusetts bars. Her presentation today is the Fair Use Factors, Their History and Application. Anna, whenever you're ready, I will pass the ball and the floor is yours.
Thanks, Margot. I think I'm ready to get started. Thank you everyone for coming today. So I'm going to talk about the history of the fair use factors, particularly focusing on the last 40 years, the time that we've had the current copyright regime in the US. And then at the end of that, I have some polls where I'll invite all of you to weigh in on whether a particular scenario is fair use or not. I'll talk through those and my answers to them, and then I'll save some time for questions at the end. If you have a question that seems really topical to what I'm discussing, do feel free to type it into the chat box, and I'll try to address them as I go, time permitting. So fair use has its roots in the English tradition of fair abridgment, which permitted certain uses of copyright materials in an abridgment context. And that was an 18th century doctrine. Pretty much as soon as the Statute of Anne, the English Copyright Act, was passed, we started seeing fair abridgment cases. The first US case to address this doctrine is Folsom Be Marsh in 1841. So that's a case that's it's not calling it fair use yet, but it's very much the spirit of our current fair use test. It's a case about two competing biographies of George Washington, one of which was published after the other and incorporated a lot of the same material. And Justice Story, who was a Supreme Court justice but was sitting on a circuit court in Massachusetts for this case, he laid out a test for determining when it's okay to incorporate material from another work and when it's not. So his test is, you look to the nature and objects of the selections made, the quantity and value of the materials used, and the degree in which the use may prejudice the sale or diminish the profits or supersede the objects of the original work. So this test continues to develop. A few decades later, we get the first case that actually calls it fair use. And it continues to develop in judge-made common law for the next 140 years. It's in the 60s and the 70s that Congress, the 1960s and the 1970s, that Congress starts thinking about revamping the Copyright Act. And those discussions culminated in the act that we have today. There have been some small amendments, but by and large, it's stayed the same over time. And when Congress wrote that 1976 act, they decided to codify fair use. So up until then, it had been a judge-made doctrine, and it could change, without regard to the statute. Congress, in 1976, they put it into the statute. And so the statute, which went into effect in 1978, is up on the screen right now. And you'll see that it's actually pretty similar to Justice Story's test from Folsom Be Marsh. So let me break it down. The first portion of the statute is called the Preamble, and it talks about a lot of uses that Congress thought would typically be fair. These are the illustrative uses: criticism, comment, news reporting, etc. And then it laid out a 4-factor test for determining whether something was a fair use. The first factor is the purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes. So under that factor, if it's a commercial purpose, it's less likely to be fair. If it's a transformative purpose or an educational purpose, it's going to be more likely to be fair. And I'll be talking more about commerciality and transformativeness here in a minute. The second factor is the nature of the copyrighted work. It's less likely to be fair under this factor if the work is unpublished or the work is creative, the original work. And it's more likely to be fair if the original work is factual. The third factor looks at the amount and substantiality of the portion used in relation to the copyrighted work as a whole. So a use is less likely to be fair if it uses the heart of the work or it uses the entire work. But under this factor, if the amount used is necessary for a transformative purpose, then the factor is neutralized. I'm also going to talk more about that in a moment. So that's going back to the transformativeness discussion that happens under the first factor. And then finally, the last factor, the fourth factor, says we look at the effect of the use upon the potential market for or value of the copyrighted work. So a use is less likely to be fair if it decreases demand for the original by acting as a substitute, if people buy your thing instead of the original thing, or if it's the sort of use that the rights holder currently licenses. That also makes it less likely to be fair. It's more likely to be fair if your use is the sort that the rights holder is not willing to license. So maybe for a negative review, for example. So this is the whole statute again, and this is how it was passed in 1976. This is the original version. So I want to talk for a little bit about commerciality, the sub-factor of the first factor, which looks at whether your use has a commercial purpose or character. Soon after the current Copyright Act went into effect, a case started working its way up through the courts called the Sony case. It's a case about Betamax video recorders. So Sony was manufacturing these video recorders, and the consumers were using them to record broadcast TV and then watch it at a later time. And when Justice Stevens writes his opinion in the Sony case, he says some extra stuff that ends up playing a big role in how courts think about commerciality under the first factor. So this is what we would call dicta, and the reason it's dicta is that the Sony case was not about a commercial use. It was about home video recording. And so Justice Stevens is kind of saying this as extra. It's an aside in his opinion. So when he's discussing the first factor, he says, although every commercial use of copyrighted material is presumptively an unfair exploitation of the monopoly privilege that belongs to the owner of the copyright, non-commercial uses are a different matter. So that whole sentence, the point of it for him is to say that non-commercial uses are okay. But first, he says that every commercial use is presumptively unfair. And then when he's discussing the fourth factor, he says if the intended use is for commercial gain, the likelihood of harm to the market for the work may be presumed. So this sets up two presumptions that are known as the Sony presumption and which have a major impact on copyright cases for the next decade or so. So this is a 1984 case. In 1994, another case on fair use comes before the Supreme Court called Campbell v. Acuff Rose. In that case, a music publisher, Acuff Rose, sued over Two Live Crew's song Pretty Woman, which was a parody of the Roy Orbison song Oh Pretty Woman. At the district court level, the trial court, the court says that commercial purpose is not a bar to fair use. it weighs against fair use, but there are all these other factors that make this use fair. When that case is appealed to the Sixth Circuit, they say that because the use by Two Live Crew is commercial, that requires the conclusion that the first factor weighs against a finding of fair use. So they're using that Sony presumption here. But when the case goes up to the Supreme Court says, if commerciality carried presumptive force against a finding of fairness, the presumption would swallow nearly all of the illustrative uses listed in the preamble paragraph. So, for instance, news reporting is usually conducted with a commercial purpose. And since Congress envisioned news reporting as being a permitted use, it can't possibly be that there's such a strong presumption against commercial use. So this case really changed the attitude of the lower courts to commerciality. And now it's over 20 years old, but it's still the most recent Supreme Court case on fair use, and it's still very important. And so this doctrine of commerciality being important but not being the end of debate on the first factor has definitely made it to the lower courts. One example is in the Authors Guild v. Google opinion, which came out last October. The court kind of summed up their past history on this question. So this is the Second Circuit, the court in New York. They say, our court has repeatedly rejected the contention that commercial motivation should outweigh a convincing transformative purpose and absence of significant substitutive competition with the original. And they cite Cariou and Castle Rock, which are earlier cases from the Second Circuit that also weigh commerciality against other factors and don't make it the entire first factor discussion. So they're saying it should outweigh a convincing transformative purpose. That's the other major part of the first factor, which I'll talk about in a minute. And then absence of significant substitutive competition with the original is the fourth factor. I see there's a question in the chat. Richard is asking, did Two Live Crew win or lose? They won, but not just because of commerciality, right? So commerciality still weighed against fair use, but there were other things in their case that allowed them to have fair use and to win. I'm going to talk about transformativeness next, so I'm definitely not done with the Campbell case. So this attitude toward commerciality, that it's important but not dispositive for the first factor, has also shown up in the other circuits. There's a recent case in the Fourth Circuit about the Baltimore Ravens' use of one of their old logos where they didn't have permission to reuse it. And the court found that it was fair use, even though the Baltimore Ravens are obviously a commercial enterprise. And then a recent fair use case from the Ninth Circuit is Seltzer v. Green Day, where a piece of street art, the Scream icon, was used as the backdrop for a concert by the band Green Day. And the court said that the degree to which the new user exploits the copyright for commercial gain, as opposed to incidental use as part of a commercial enterprise, affects the weight we afford commercial nature. So because this piece of street art was just a small part of the backdrop, which was only a very small part of why people would buy tickets to come to a Green Day concert, this use was incidental, and so commerciality was not as important. All right, so that's one sub-factor of the first factor. The next one I want to talk about is transformativeness. So as someone has mentioned in the chat, transformativeness is very important in fair use today, and there's sort of a turning point with the Campbell case that I mentioned earlier. But the transformativeness doctrine actually has roots before Campbell. In the late 70s, there was an article trying to frame fair use in terms of productive use. And that idea appears in the dissent in the Sony case, where they're talking about why they don't think that the Betamax machines are fair use. And so Justice Blackmun says that each of the preamble's illustrative uses reflects a common theme. Each is a productive use, resulting in some added benefit to the public beyond that produced by the first author's work. And they contrast that with ordinary use, ordinary copying of the sort that you do with a Betamax machine, where you're recording broadcast TV to be watched later. That's ordinary use in Justice Blackmun's framework. So productive use remains a theme in cases through the later half of the 1980s. And then in 1990, Judge LaValle, who at that point was a trial court judge in the Southern District of New York, and who now is a judge on the Second Circuit, the court above the Southern District of New York, he wrote this article, Toward a Fair Use Standard, that was published in the Harvard Law Review. So in this article, he says that judges are not seeking cohesiveness and trying to create a cohesive doctrine of fair use, and they should be. And then he lays out how he thinks the four factors should be analyzed. And specifically, when he's talking about the first factor, he says, I believe the first factor turns primarily on whether and to what extent the challenged use is transformative. The use must be productive and must employ the quoted matter in a different manner, or for a different purpose from the original. If the secondary use adds value to the original, if the quoted matter is used as raw material, transformed in the creation of new information, new aesthetics, new insights, and understandings, this is the very type of activity that the fair use doctrine intends to protect for the enrichment of society. So he is calling on that doctrine of productive use, but now he's using a different name for it, and he's kind of recasting it a little bit. So that's in 1990. In 1994, when the case about Pretty Woman, the Two Live Crew case, Campbell, makes its way to the Supreme Court, Justice Souter writes that the central purpose of the first factor is to see, in Justice Story's words, so he's going all the way back to 1841 now, whether the new work merely supersedes the objects of the original creation or instead adds something new with a further purpose or different character, altering the first with new expression, meaning, or message. It asks, in other words, whether and to what extent the new work is transformative. He also cites Judge LaValle's article. So he is incorporating the test from Justice Story, the idea of productive use as expounded by Justice Blackmun, and then written about under this new name by Judge LaValle. So transformativeness becomes very important because, as I said, this is the most recent Supreme Court case to really talk about fair use. In the Campbell case, the work at issue, oh, sorry, I forgot about this slide. So they're saying that transformativeness is not required for fair use, but when a work is transformative, it's at the heart of the fair use doctrine. And it can also overcome commercialism, as I just mentioned. So the Campbell case is about a parody. Two Live Crew is a rap group, and they use Roy Orbison's song to poke fun at Roy Orbison's song. And Justice Souter says that parody has an obvious claim to transformative value because it provides social benefit and it's similar to criticism. Criticism being one of the favored uses from the preamble. This case is 22 years old, and in those 22 years, the Transformative Miss doctrine has been applied in a lot of cases that aren't cases about parody. And so some of those examples are image search. There are a couple of cases from the early 2000s that are about searching the web for images and reproduction of the image entirely by the image search engine, right? So when you get your results today, almost everyone is using Google image search, right? But your Google image search results include tiny versions of the image. And Enriquez, which created an early search engine, was doing the same thing. They were providing really small, low-resolution thumbnails in their image search results, and this artist, Kelly, who was portraying scenes from the American West, brought suit, and Enriquez was successful with a fair use defense because they were using Kelly's images not to portray the American West, not for their aesthetic value, but as an index of the web. And so they were being transformed. The test today for whether something is transformative is whether it's being used for a different purpose than the original. So we would say that Kelly's purpose was aesthetic and Enriquez's purpose is indexing. There was another case in the Ninth Circuit shortly after that involving Google and Perfect 10, and they kind of recap Kelly. They say that even making an exact copy of a work may be transformative so long as the copy serves a different function than the original work. We've also seen transformativeness as a successful part of a fair use defense in several other contexts. One is mass digitization, the cases involving the Google Books Project, so Authors Guild v. Google and Authors Guild v. HathiTrust. Both of those cases use the transformativeness analysis to say that these books were originally produced, say, to entertain, in the case of a fiction book, or to provide information, but what HathiTrust or Google, what they're doing, they're using them for indexing. So it's a similar logic to the image search engine cases. There's also a plagiarism detection case, the iParadigms case. So a group of students were required to upload their papers to Turnitin, the plagiarism detection website. And Turnitin then made copies of their papers and kept them, both to check whether they had plagiarized and to check later on whether anyone plagiarized them. And the courts and the students sue for copyright infringement, and the court says that's fair use because the students are writing their papers, creating the original work with the purpose of, conveying information for their teacher and also for getting a good grade. And the company, iParadigms, Turnitin, they're using the papers to detect plagiarism, so it's a different purpose. And then there's also a publishing case that is really similar to the image search engine cases because they're using small versions of concert posters in a coffee table book. So it's a coffee table book about the Grateful Dead, and Dorling Kindersley, the publisher, uses these concert posters in a kind of thumbnail version to show points on the timeline where the concerts took place. And an archive that has copyright in the posters sues. And the court says that because they're using them not to advertise a concert, but to share historical fact, it's a different purpose, and so it's transformative. Transformativeness has really taken over fair use analysis because it doesn't just come under the first factor. It also has strong impact on the third and fourth factors. On the third factor, which considers the amount and substantiality of the portion used, transformativeness can sort of neutralize that, because in Campbell, for instance, they say that a parody needs to be able to conjure up the original. There's no point making a parody if people don't know that you're parodizing something. So you have to use enough of the original to convey that you're using the original. And so that use is excused. The third factor is not going to weigh against you on that. In the Bill Graham case, the Grateful Dead coffee table book case, there's a really nice summary of this principle. They say, neither our court nor any of our sister circuits has ever ruled that the copying of an entire work favors fair use. At the same time, however, courts have concluded that such copying does not necessarily weigh against fair use, because copying the entirety of a work is sometimes necessary to make a fair use of the image. So that's how the third factor can be neutralized if you have a transformative purpose, and if what you're using is necessary to it. And then finally, transformativeness also has impact on the fourth factor, the effect of the use upon the market for the work. First of all, Campbell says that the Sony presumption, that if something is commercial, there's market harm is presumed. Campbell says that doesn't apply in transformative cases. Also, there's this idea that if you're copying in order to serve your transformative purpose, it's unlikely that you're going to be creating a substitute for the original. So if you have this transformative purpose, the fourth factor is less likely to be a problem for you. So that comes up in the Authors Guild case. There's a caveat to that, which is that transformative copying can nonetheless harm the value of the copyrighted original if done in a manner that results in widespread revelation of sufficiently significant portions of the original as to make available a significantly competing substitute. What the court is talking about there is that Google displays a snippet of the work when you do your text search of the Google Books corpus. And the court says that Google has correctly put in safeguards to prevent someone from being able to see the entire work by cleverly sending many, many queries to the search engine and getting snippets back that they could then assemble into the original work. It's not possible to do that with Google Books because of a variety of safeguards that they put in place, including blacklisting certain pages, which never come up in snippet view. All right, that's kind of getting into the weeds. I see that there is a question in the chat. Is making a fanish video using portions of a movie or concert transformative? Well, whether something is transformative depends on whether your purpose is the same or different from the purpose for which the work was originally made. So if a movie is originally made to entertain and you make an entertaining fan video using clips from it, that's probably not a transformative purpose. If, on the other hand, you make a critical video that shows that there are not very many women in the movie with serious roles, right? So there are different kinds of fan videos that might make a critical point, in which case they'd be using the material for a different purpose, and those could be transformative. But it's going to depend on the specific video. All right, the last sub-factor that I want to talk about today is publication status. This comes in under the second factor. I'll pause for a minute. There's another question in the chat about a parody of an action movie. So Campbell is the leading fair use case, and it's about a parody. And so if, like, the law is more well settled in the world of parody than it is in any other area of fair use. So in that case, you kind of want to look back to how the Campbell analysis went. And it's generally going to be favorable, but it really depends on whether a court thinks that you have a parody or if you just have something that you're calling a parody. Yeah, so the Hitler videos, they're not all fair use. There's this doctrine that you have to be poking fun at the original in order to get parody status under copyright law. Otherwise, you're a satire, and the fair use analysis is less favorable. So most of those videos are using the Hitler footage to make some other point, right? To say something else entirely. They're not really commenting on the original work. And so it's possible they're fair use, but it's going to be less favorable overall. All right, I'm going to move on from transformativeness now so that I can get through publication status and still have time for questions and polls. So in the Harper and Row case, which is another fair use case in front of the Supreme Court, it's about Gerald Ford's autobiography, which was prepared for publication and was about to be published. And in fact, they had a contract with Time magazine to publish excerpts from it as part of the publicity around the publication. And somehow the Nation, one of Time's competitors, got a copy of the manuscript, and the Nation published part of the manuscript. Specifically, they published the part where President Ford described his reasons for pardoning President Nixon. So it was a part of the work that the public really was interested in. And so in that case, Justice O'Connor says the scope of fair use is narrower with respect to unpublished works. While even substantial quotations might qualify as fair use in a review of a published work or a news account of a speech that had been delivered to the public or disseminated to the press, the author's right to control the first public appearance of his expression weighs against such use of the work before its release. The right of first publication encompasses not only the choice whether to publish at all, but also the choices of when, where, and in what form first to publish a work. So remember, the court here is talking about something that's been prepared for publication and is on the brink of publication. But that doesn't exactly make it into this text, right? They don't say this only applies if you're about to publish it. And so the lower courts, in particular the Second Circuit, really run with this. So Harper and Row is a case from 1985. And in the late 80s, publication status becomes really important, especially in the Second Circuit. So there's a case about a biography of J.D. Salinger where they use excerpts from his personal writings and letters. And the court says, we think that the tenor of the court's entire discussion of unpublished works in Harper and Row conveys the idea that such works normally enjoy complete protection against copying any protected expression. So they've taken Harper and Row, where Harper and Row is saying this is one factor, and it's very disfavorable, but it's just a factor. And in Salinger, they say unpublished works normally enjoy complete protection. A couple of years later, there's a case involving the writings of L. Ron Hubbard. Again, they're being used in a nonfiction work. And that case, the district court says it's different from the Salinger case. because it's an even better case for fair use. And the Second Circuit overturns that, concluding that they say the district court concluded that diminished likelihood is not the same as impossibility, and that normally does not mean inevitably. Remember that the Second Circuit had said that normally unpublished works get complete protection. They said that in the Salinger case. And so in the New Era case, the trial court used that to say this is a really strong case for other reasons for it to be fair use, so we can still call it fair use. And the Second Circuit said, no, you're wrong. There's no need for such an approach. Where use is made of materials of an unpublished nature, the second fair use factor has yet to be applied in favor of an infringer, and we do not do so here. So after the Salinger case and the New Era case, there's kind of a problem in the publishing industry in New York, because suddenly it's really dubious to publish nonfiction that draws on archival materials. And Judge LaValle, who is the lower court judge in both of these cases, who also wrote that Harvard Law Review paper on fair use, he, when he's preparing that article, he talks to the general counsel for one of the publishing houses, and she says, you know, we're really worried because a lot of our catalog, you know, a lot of our published works are now of questionable copyright status. They might be infringing because of these new Second Circuit decisions. So Congress does something that it hasn't done in any other case. It amends the statute. It adds this line at the bottom. The fact that a work is unpublished shall not itself bar a finding of fair use if such finding is made upon consideration of all the above factors. So Congress basically overrules the Second Circuit. And this is the version of the fair use statute that we have today. If you're really paying attention, you'll see that it says it was also amended. Well, it was amended in both 1990 and 1992. The 1992 amendment is the one about publication status. The 1990 amendment is even more minor. It's just the addition of and 106A at the top, which says that fair use applies to the Visual Artists' Rights Act, which gives some supplementary rights on top of the traditional economic rights of copyright. So this is the current text of the statute. Since 1992, the lower courts have definitely applied the new statute to their cases. One example involving an unpublished manuscript that's been used for scholarly purposes is the Sundaman case, where they say, while the fact that the work was unpublished militates against a finding of fair use, it does not foreclose a finding that the defendant's use was fair. So that's very similar to the statutory language. So you can see that it's been put into practice. All right, I know there are a few questions in the chat right now. I'm actually going to hold off since we're at the end, and I'm going to be talking about some hypotheticals that may illuminate these things. And then we'll have time for a question and answer period here in a minute. So, Elois, I think I'm ready for the first poll now.
All right.
So this first hypothetical, which I'm calling local fauna, a library is digitizing rare nonfiction works about local fauna from its collection, then making the full text of the works available to the public via its website. The library has been unable to identify the copyright holders for 3 of the works, all of which are out of print and are not available for purchase as ebooks or from any print-on-demand service. Assuming the 3 books are protected by copyright, would the library's digitization of them qualify as fair use? So go ahead and submit your answer, and then in a moment here I'm going to start talking through my answer. Okay, so I'm going to go ahead and start talking through my answer. I think the poll is tabulating. So I think that this qualifies as fair use, and here's why. For the first factor, the purpose and character of the use is nonprofit, it seems, and it's educational. It's being done by a library. For the second, it's not clear if this is a transformative use. It's kind of on the edge of being transformative, but because they're having the full text searching, like in Authors Guild, and so it's pretty favorable under the first factor. For the second factor, these are books about local fauna. They're nonfiction, so to the extent that the second factor matters at all, it's going to weigh in favor of fair use, right? The material is not unpublished, and it's factual rather than creative. However, the second factor is not super important, so it's not, not going to weigh that much. For the third factor, it's a little troubling because they are using the entire work, but I don't think that's dispositive here, and the reason is the fourth factor. So I've said that these are works that are out of print and are not available for purchase as ebooks or for print on demand. They've also tried to find the copyright holders, but they haven't found them. So these are orphan works. They're out of commerce orphan works. And so there is not a market that they would be, because the works are out of commerce, the library's copies are not going to compete with a licensed version in the market. And so I think that the fourth factor weighs in favor of fair use. So this is certainly not a totally clear-cut case, but I think it's a good case for fair use. And we can see that it seems like the majority agrees with me. There's definitely a significant minority there saying that it's not fair use. I think everyone can see the poll results right now. We've got 36% saying it's fair use, 22% saying it's not fair use, and 42% did not vote. But here's another opportunity to vote. Here's poll number 2. So in this hypothetical, a researcher prepares the obituary of another scholar in her field to be published in a scholarly journal. Along with the obituary, she publishes a photograph of the scholar, which she has cropped from a group photograph taken by a professional photographer. Does the researcher's use of the photograph qualify as fair use? While you're voting in poll number 1, I see there's a question about artistic illustrations in the fauna books. I think that even if it's an illustration, if it's an illustration in a scientific nonfiction book that's intended to convey, you know, the anatomy of the plant or this is fauna, the anatomy of the animal, there's a good case for that being on the factual side. So I'm not particularly concerned about illustrations in those books. The other thing to remember is that the second factor is just not that big of a factor in the overall analysis. So it's more important to look at factors 1, 3, and 4, which weigh more heavily. All right, so to get back to the obituary photo question, I think this is probably not fair use. Again, it's not a total slam dunk for the plaintiff, but it's not looking great. So for the first factor, we could say that it has an educational purpose. It's being published in a scholarly journal. It definitely doesn't seem to have a commercial purpose, but it's also not transformative. So the first factor is not incredibly helpful. For the second factor, it's a photograph, so we think of it as being more creative. On the other hand, some courts have said that where a photograph is really accurately recording its subject, then it's more factual under the second factor. Then for the third factor, the amount taken, the amount used, she's not using, the researcher is not using the entire group photograph, so that's helpful. But, you know, that doesn't make it automatically fair use. And then finally, for the fourth factor, the market substitution, you know, it's hard to say. The professional photographer may well be licensing for this kind of use, which would weigh against fair use. So again, I think this is a close one, but probably less likely to be fair use than hypothetical number 1. Someone is asking about 10% in the chat. What if it represents less than 10% of the total photograph? The 10% rule is not a rule, so that's not going to matter. So the Georgia State case is a good example of this. The district court judge, the trial judge in that case, said that she could apply a 10% rule to determine how the third factor would weigh in the fair use analysis for the E-reserves in the Georgia State case. But the 11th Circuit has flatly rejected that and said, no, you have to look at the quantity and quality of what's taken, not a strict rule. All right, so then this is my final hypothetical, and then we'll open it up to questions. So poll number 3, a college has digitized a personal archive from its collection. Each item from the archive has been scanned and cataloged. Textual items have been OCR'd. The college archivist has also prepared a finding aid for the archive. The finding aid, the metadata, and the text are all searchable on the college website, where copies of all the items in the archive are available to the public. The deed of gift transferred all of the donor's copyrights to the college, but the archive contains letters and photographs the donor received from others. Is the college's digitization of those items fair use? So once the poll for this one starts tabulating, I will talk through my analysis. All right, so for this one, I think it is fair use. I think it's the closest case of the 3 hypotheticals that I've posed today. But when we look at the first factor, it's an educational purpose, it's not commercial, and I think there's a very good argument for transformativeness here. They're using these items from the archive not for their original purpose, right? So if there's a letter in the archive that someone wrote to the donor, the scanning of it and putting it on the website, it's for a different purpose. The letter writer wrote the letter to convey information and to ask information, whereas the college is putting it up for historical purposes, for scholarly purposes. Also, they're putting a lot of extra context around it, which is really helpful if you're looking at cases like the Grateful Dead coffee table book case. So that extra context that they're providing is going to mean that it's more likely to be transformative. The second factor is going to vary depending on whether it's a letter or a photograph, whether the letter has poetry in it or is more like a shopping list, right? So the second factor is going to vary a lot depending on which work we're talking about, but as I've said a couple times now, it's not very important in the overall analysis, and so I'm not too worried about the second factor here. For the third factor, they are using the entire work. To the extent that there's a heart of the work, they're also using the heart of the work, right, because they're copying the entire thing. But I think that that's justified by their transformative purpose. So in the indexing cases, courts have said that, you know, there's no point in making an index if you skip half of the pages of every book that you're indexing. And here, you know, it's not helpful to have someone's full personal archive digitized and then only digitize half of every letter that's from another person, right? So the amount used is justified by the transformative purpose, so the third factor is going to be neutral. And then finally, the fourth factor, the impact on the market for the work. That's going to vary depending on the original work. I don't think that there's a market at all for most of the letters. You know, again, for the copyright in the letter, it's possible that the physical letter might be valuable if it's signed by George Washington or something, but the copyright in the letter is not going to be incredibly valuable. And probably there's no market at all, so they're not acting as a substitute. With the photographs, it might be a little bit different depending on whether any of them are, you know, photographs that have been used in a commercial way, possibly like an AP photograph or a Getty Images photograph, something that has a licensing market. It's going to be less favorable, but it's not an absolute bar. So with the caveat that it's going to depend on each particular item that they've digitized, I think that this is fair use. So that's the end of my formal presentation, but I'm happy to do question and answer now. I see one in the chat that I'll address quickly. Doesn't the copyright for the letter belong to the letter writer? Yes, it does, right? So that's why you would have to rely on fair use if you wanted to do this. You have the copyrights from the donor, but you don't have the copyrights for all of the material that the donor held onto that's copyright to someone else, and letters would be among that. This is a big problem in digitizing archives because there are so many copyright holders. Someone else is asking about privacy rights. There could possibly be privacy rights implicated in the personal archive hypo, but, you know, this is a fair use talk, so I'm not covering those right now. Sorry, guys, I'm just trying to catch up to the chat a little. So there's one question from Emily Ford saying, when do we choose fair use over other provisions such as Section 108 or the Teach Act? So for those of you who aren't familiar with Section 108 and Section 110, the Teach Act, they both provide specific exceptions for certain behaviors, and they're much more straightforward than fair use, right? So fair use could cover many from a range of behaviors, but Section 108 really only covers very specific uses by libraries. First of all, you have to be a library or an archive to even take advantage of 108, and then only certain behaviors are excused. So for me, that's how you choose, right? If you can tell that your behavior is excused by 108 or 110, great. You know, they provide a lot more certainty than fair use does. But if not, or if what you want to do seems sort of analogous to 108 or 110, but the technology has changed, and so what you're doing is technically not permitted by 108 or 110, then fair use can be really helpful. I see Margot is posting a question from earlier. Art history scholars are famously cautious about reusing images in their scholarly analysis, especially in digital contexts, because the licensing/permission granting business is robust. It has always seemed to me as a publisher that the first three factors should override the fourth in these cases. Thoughts? Well, it's certainly possible for the first three factors to override the fourth factor. That's going to depend a little bit on what circuit you're in, because the different circuits will balance the factors a bit differently. Some of them are still saying the fourth factor is the most important. I live in Chicago, and in the 7th Circuit here, you know, the court is still saying that the fourth factor is the most important. Some other circuits, like the 2nd Circuit, say that if something is transformative, that's really going to drive the analysis. So unfortunately, it's going to vary, but I do think it's definitely possible for the first three factors to override the fourth. A question about putting DVDs on reserve that are personal copies. I like this question because it gets to something that I didn't mention, which is that there are plenty of uses of copyrighted materials that are permitted before you even get to fair use. Uses that don't implicate the first factor. That don't implicate copyright at all. Like, you're not infringing when you lend a DVD to a friend, and you're also not infringing when you, at the library, have a DVD that's loaned out to students, even if it's a personal copy. So that's just, you don't even have to go to fair use for that question. Jane Monson is asking, what about fair use by for-profit educational institutions like the University of Phoenix? Great question. So the first factor considers three big things. One is your use transformative? Another is your use commercial? And the third is it one of the favored purposes from the preamble? So I would think that if a for-profit institution were trying to take advantage of fair use and they got sued, the first factor could still favor them. Because remember that commerciality has waned in importance a lot. And so if someone like Google can take advantage of, can have the first factor weigh in their favor, I definitely think that an institution that has a profit motive but still has an educational mission could also potentially have the first factor weigh in their favor. I don't think that their commerciality is going to really hurt them if they're making a transformative use or if they're doing an educational use that's really close to the heart of fair use. There's a follow-up question on the personal copy of the DVD note. The DVD has to be properly procured, correct? Can't be a pirated copy? Yes. So technically the thing that allows you to lend copies of copyrighted works is the first sale doctrine. And the first sale doctrine only applies to works that have been lawfully made under this title, which is to say works that have been created in a way that does not violate copyright law. So if you have, you know, a market purchased DVD, you can absolutely lend it. It's not a problem. You don't have to worry about whether it's fair use because it's not infringement. If you have a DVD that you've made and you have used fair use to include some segments of copyrighted material on your DVD, if it's fair use for you to prepare the DVD, then the first sale doctrine will allow you to lend it because it's been lawfully prepared because it was fair use. There are quite a few questions about course reserves, and I also see that we're getting to the end of the hour, so I want to address that quickly. The Georgia State case, which I mentioned briefly, is the big case on e-reserves, electronic reserves. really, it's much less likely that traditional conventional reserves would implicate fair use. They probably don't, except unless if you've had to, photocopy an article to put it on reserve or something. But in the case of electronic reserves, what the 11th Circuit has said, and none of the other circuits have addressed this issue, but they've said that it really depends on what type of work you're putting on reserve, so under the second factor, and whether it's available to be licensed for use in electronic format. So that's the fourth factor. And then the third factor is also going to come into play, and that's going to depend on your individual reserve assignment, right? So if you put an entire novel on reserve and putting it on electronic reserve means that you are making copies of it and distributing them within some kind of password protected area to the students in the course. Putting the entire novel on reserve is probably not fair use unless, again, the fourth factor is really favorable to you because it's out of commerce and it can't be licensed in any way. So maybe like an orphan work novel you could put on e-reserve. But in general, whole novel, creative, using the entire work, probably not fair use to put it on electronic reserve if there's a market for it. On the other hand, if you have something that's pretty factual, if you're using a small part of the work, if there's no licensing market, then it can be fair use. So in the Georgia State case, the circuit court said you have to look at each one and determine individually whether they're fair use. I'm happy to stick around and keep addressing questions as long as that's not a problem somehow, Margot.
No, that's fine. If you have a few more minutes, that would be great.
Okay, great. Yeah, so Laura is saying in the chat, notes that the Georgia State case is still ongoing. It is, and so the 11th Circuit basically gave instructions to the district court to redo its fair use analysis on each of the 74 works. And so we're still waiting to find out what they say. Okay, there's a question about dissertations available online through a repository and through ProQuest. How do you weigh the inclusion of copyrighted, highly creative content, even if used for the purposes of scholarly analysis/criticism? So a case that I would analogize this to, and that there might be royalties involved, especially if it's on ProQuest. You've been de-emphasizing commerciality, so perhaps this is a secondary concern. So first of all, yes, I would say that commerciality is not going to be a driving factor if you have a transformative use, especially if you're in the Second Circuit or the Ninth Circuit. In the Seventh Circuit, that's maybe less of a trend. But the case that I would actually look to for this is the Sunderman case, which I mentioned earlier. So in that case, there's an unpublished manuscript of a book, and the person who controls the manuscript, the physical object, but does not control the copyright, makes a copy of the manuscript, a copy of the physical object, for use by a scholar who is preparing a critical review of the work. So first, they copy the entire work so that she can do her scholarship. And then she excerpts certain parts of it in the critical work. So there's the entire copying, but that version is not available to the public, right? So it's not really a substitute. So the fourth factor is okay for that. And then there's the big excerpts. And the court finds that this is fair use, even though the material is unpublished, even though they use pretty big chunks of it, because there's no market for it. It's not on the market. So that's an example of something that's highly creative. It's the novel, the content of a novel, and it's used in the academic work, and it's still okay. Okay, Julie Ecker is seconding a question. Thank you for doing that because I didn't see it the first time it was asked. Is it deemed commercial if there's a small fee to cover costs? This is a tricky issue and it's definitely not well settled, but I think because commerciality is less important these days, if there's a small fee and it's not actually giving the user profit, it's probably not going to make a big difference on the first factor. So if there's something else about the first factor that favors fair use, such as being one of the preambular purposes, like it's for criticism or comment or teaching, or if it's transformative, then I think that's, not something to worry about. Again, Google succeeded with fair use despite definitely having some commercial motives for the Google Books project, right? So it's not dispositive anymore. And the Campbell case is another good example there. So of course, Two Live Crew made this song, they recorded it, they released it commercially. It had a commercial purpose, but the other things about it, particularly its transformative nature, its critical nature, those things made the first factor favor fair use. I just put up my final slide, which I had forgotten about. It's some further reading that I would recommend if you're interested in some of the stuff that I mentioned today. So there's a great empirical study of fair use cases by Barton Beebe. Unfortunately, it's now a little bit old because he had to end it in 2005 because he was publishing in 2008, I think. But it has a nice analysis of how the factors balance and how their balances change over time. I also recommend Professor Fisher's video on fair use, which is part of the Copyright X lecture series. And then finally, if you're interested in my first slide, fair use before 1978, and particularly fair use before 1841. What is all the stuff that led to Justice Story's opinion? Then I recommend The Prehistory of Fair Use by Matthew Sagg. All right, I'm looking at more questions. Is digitizing an orphan video from VHS more of a fair use or 108/teach? It would depend on why you're digitizing it. So if you're digitizing it just for preservation, I think you could take advantage of part of 108. I don't think that you can take advantage of any part of 110 because that's all about performing and displaying works. I'd have to look at it, obviously, look at the text, but I think you'd be in better shape with 108 than 110. However, 108 doesn't let you do a lot of things that you might want to do with your orphan video, like show it. And so you might have to rely on fair use for that. Yeah, okay, and Laura Bertle has a great response to that. So the obsolete technology part of 108 is probably going to get in the way of using 108 for your VHS digitization. What about libraries that put copies of textbooks on reserve for multiple semesters? Casey Cobb, maybe you can add in the chat whether you're talking about electronic reserve. If you aren't, if you're talking about conventional reserve, this is definitely not a problem. That's totally fine. Again, it's because of the first sale doctrine. If you own a lawful copy of a work, you are very much free to lend it, to sell it, to, let other people use it, as long as you're in the US. If you're in Europe, there are other provisions that make things different, but otherwise it's fine. Michael Belcosa, another great question. free poetry seminar. Instructor wants to make copies for the attendees of a dozen poems and the entirety of each poem from a poet with a large body of work. So is it fair use even though the poems are not excerpts and may be longer than 250 words? So first of all, don't worry about the 250 word thing. It's not part of the fair use doctrine. So this turns on what is the work that we're talking about when we look at factor 3. Let me get back to my good slide for this. So you'll see that factor 3 says the amount and substantiality of the portion used in relation to the copyrighted work as a whole. Your example of poems is a great example here because it is a little unsettled. If you have, say, an anthology of poetry and you copy only 4 poems out of it, then the court would probably say that the copyrighted work is the anthology. But if instead you're like, you know, copying individual poems that have appeared in a variety of publications, then the whole work is the poem, right? And so another analogous problem is the whole work the album of musical tracks, or is it the individual track? So this is an area where it's not well settled. There are different approaches in different circuits. But probably this is a case of copying the entire work, and so you're going to need other justification. The third factor will weigh against fair use. It's possible it could still be fair use for other reasons, but it's probably going to weigh against fair use on the third factor specifically. Okay, email reference. Is it fair use to scan and send over email to a researcher based in Europe 2 pages of a book under US copyright as the answer to an email reference question? So underlying this question is whether you're being governed by the US copyright law or European copyright law when you do this. It sounds like US copyright law as long as you're based in the US, in which case then we go ahead and talk about fair use. 2 pages of a book, supposing it's a decent sized book, you're going to be in great shape for the third factor. Then you have to look at the other 3, and you know, they're really important. The first factor is probably not transformative, although it depends a little bit on what you're doing, but it probably is teaching or scholarship or research, so the first factor might be somewhat favorable. The second factor, if this is, you know, 2 pages that are basically a table of data, you're going to look, it's going to be much more favorable than if it's 2 pages that are a collage of photographs. And then finally, for the fourth factor, you could consider whether what you're offering the professor is going to act as a market substitute. But if it's just 2 pages, it's hard for it to be a market substitute. So in general, that seems like a good case for fair use. Placing something on reserve that says do not copy. Again, this is fine. As long as we're talking about physical reserve, it's very straightforward, which is what I'm assuming here. But I'm not, I don't know. Debbie Hathaway, are you talking about physical or electronic reserve? So if it's electronic, the do not copy restriction probably doesn't have a ton of extra force beyond copyright law. In fact, I'm going to go ahead and say that it doesn't, although if he has somehow become party to a contract in purchasing the workbook, it's possible that there are additional contractual restrictions on him not to copy it. But in general, just putting do not copy on your work cannot erase someone else's fair use defense. And so if it's fair use to put it on reserve, which it might not be if you're using the entire work and it's electronic reserve, you know, where they're going to have copies that could be market substitutes. But if it is fair use, the fact that it says do not copy is not going to matter. Jamie Lee is asking, the use of the photograph taken by a professional photographer, is the photographer's copyright that is it the photographer's copyright that the scholar is infringing upon? Yes. The photographer has taken a photo. Maybe they sold it to the family. I was actually picturing a, you know, institutional photo. But even if the photographer has sold physical copies or digital copies to someone else, the photographer is going to retain his copyright unless he explicitly transfers it. So yes, if he transfers it or if he gives a license, if he gives permission to use it, then that's fine, but he would have given it to the family or to the institution, not to this researcher who's preparing the obituary. So she would still need to get permission from someone who has the right to give that permission. Or she can take advantage of fair use if you think it's fair use, which I don't. All right. Seems like we are maybe at the end of the questions, so thanks everyone for coming. I will keep sticking around for a little bit if anyone has more to ask, but otherwise, talk to you later.
Yes, thanks everyone for coming, and Anna, thank you for the extended Q&A time. That was really fantastic. As we mentioned earlier, the session has been recorded, and we'll send it out to everyone via email in the next day or two. It'll also be linked from the ACRL website, so if you have colleagues that are interested in finding the recording, it'll be available through the ACRL online learning page. So thanks again, everyone. Have a great afternoon.